Tim, I see you're here as well. Did you want to say a couple of words to start us off, or shall I dive straight in?
No, please, just jump right in.
Thank you, Mike. Okay, so hi everyone. Welcome to the SME review. This is our last one before the holiday season. So uh, basically, as I said on the notice, there's a bunch of relationship terms that we need to flesh out. So last time we looked at the details of beneficial ownership and registered share ownership and the distinctions between those, and we cleared up a few mysteries in the previous draft of the model around some of those terms. Now, looking at what we have in the hierarchies, let's just have a look at what we have at the moment, particularly around corporation, and I then want to go up a couple of levels and look at a couple of other questions around what other kinds of relationship exist and are of interest and can be meaningfully modelled. Do please feel free to raise a hand, or better still, raise a
It is.
question
I
in the question
apologise for
box
being
because
late.
I can
Of
see that in my
naturally the
thing.
other call that I was just getting started had technical
Oh,
problems.
I
So
think Carol needs to
it's
mute,
just
or
one
maybe
of
I can
those
mute her.
typical when you have two meetings that
Give me
start
a
at the same
second.
time.
Carol, you need to go on
You're going
mute.
to end up with one that delays.
Muted.
I just muted her.
Thank you.
I'll unmute her later if she behaves. Excellent. So thanks all for bearing with us. These things always seem to start a little untidily. Bear in mind we have this concept of a party, and we talked about a party is anything that stands in a role, and we cleaned up the whole question last time of what sorts of things can be and what sorts of roles, and shareholders in particular can be anything that can be a party. That can include informal organisations. This is all another diagram, but just talking it through. Informal organisations as well as formal organisations with or without legal personhood and so on. And one such thing is an owning party, anything that can own something. And incidentally, we can also talk about the opposite, anything which is owned. So we can talk about subsidiaries versus parents and things like that based on this kind of ownership hierarchy. We then had the concept of a shareholder. Again, that can be anything that can be a party. It need not be a legal person. And then from shareholders, we've got two lots of terms. So we talked last time about ownership. We have beneficial owner. We also have the registered owner of shares, the difference between those and so on. That's all in the ownership side. And then we did a lot more work earlier on the control side, and we have, for control, a voting shareholder. And you probably see in some data feeds that you'll have percentage control ownership as well as, or percentage voting ownership as well as percentage ownership. A lot of the time we talk about ownership as though they're the same thing because most shares are voting shares and so on. But when we want to talk about the precise nature of things like parent and subsidiary and so on, we've needed to narrow down exactly what we're talking about, and that means that there's a lot of other things which weren't that exact thing. So here we're talking about voting shareholders. This is the stuff that we've had in the model all along. I'll just run through it quickly to show what it doesn't show. So here we are talking only of holders of, for example, ordinary shares that have a vote per share, or extraordinary shares with additional numbers of votes, but not shares that do not have votes, such as they are. And then we also narrow that down further to talk about that which is not only a voting shareholder, but is itself a company, because when we talk about part owners, parents, subsidiaries, we're talking about relationships between one company and another, not between any business entity and any other business entity, but between one company and another. So that's what we've narrowed it down to so far, and that's in voting ownership. So there's two questions I want to talk through, and I'll just point to where they are first. So one, of course, is having talked about percentage of voting ownership and the terms that are derived from that, which are basically control terms. There's also the question of ownership terms with or without control. So this isn't mutually exclusive with control ownership because most shares are voting shares. So most ownership of a incorporated company comes with control of that incorporated company via the votes in voting shares. So the question, though, then becomes, What about, do we have meaningful terms? Do we have a requirement to think about percentage thresholds of ownership, regardless of whether it's control? So, 25% ownership for LEI purposes, for example, is described purely in terms of ownership, not in terms of control ownership. I don't know whether that's deliberate or whether it's because they're usually the same and we're just getting a bit more precision here. So we need to consider whether we need a similar hierarchy of kinds of party, or kinds of related entity based on percentages of pure ownership, or whether in fact we're only interested in control ownership. Are those both meaningful concepts? And what do you call it if something has 50% ownership but isn't necessarily 50% voting ownership? That's one set of questions I'd like to unpack. There's a second set of questions as well. So all of these controlling relationships we've talked about, I narrowed it down deliberately to cover what I think we're talking about most of the time, and that is ownership with control by a company. So this little blue line that says identity is saying that the party which has some shareholding in a company is itself a company. Now, clearly, as we've seen, anything can hold shares and anything can hold voting shares. So what do we call it if, say, the 50% plus one owner of voting shares is not a limited company and therefore doesn't have this identity relationship, but is any kind of body corporate, any legal person that is an organization, or B, any kind of formal organization, or even C, for that matter, any other kind of thing that can hold shares. So what do we call it if, say, the Emir of Kuwait was to be a 25% shareholder in some entity? Clearly he's not a parent because he's a person, not a company. I know it sounds like we're splitting hairs, but having narrowed down on the precise semantics of the terms we're usually talking about, we need to think about what are the precise semantics of other similar but different terms. So that's really our big question for today, is if ownership is something that's based, or the ownership and control relationships we've normally talked about are specifically control ownership and specifically by companies. What about control ownership not by companies? What about ownership not with control? And there's a third thing as well, which is in this note, which is, and this is actually a more fundamental question. All of the stuff I've talked about here is about shares, because the mechanism for owning is that you hold equity, and the mechanism for equity is that the entity has shares, and an entity which has shares is either an incorporated company or a partnership incorporated by the issuance of shares. In other words, it's some entity which has equity which people can hold. So let's start with the first and simplest question, and this is more of a legal question, if you like. Is ownership completely synonymous with the holding of shares, or are there other ways in which things can be owned? Because if there are other ways in which things can be owned, then things other than incorporated companies or partnerships that are incorporated with shares can be owned. But if in fact they're completely synonymous, that equity is what you can own, then what do we call the other kinds of ownership, and what other mechanisms are there for owning a thing other than that thing having shares? So can you own a stake in something which is not itself incorporated by the issuance of shares? So let's start with that, and then I think I've given you an idea of the landscape of the other questions, the other things that are outside the Venn diagram of the kinds of relationships we've already talked about. Okay, so firstly, any quick questions, but secondly, and more important, does anybody know the answer to that question?
Partnerships are actually not done by share.
That's right. So do we talk about them being owned or not?
Partnerships are owned. They're jointly owned, but individuals own pieces of they own the partnership, but they share in the profits and losses effectively.
That's right. They're jointly and severally liable.
They're not actual shares distributed.
Yes, so we're talking about unincorporated partnerships here. We talk about, when we talk about the partners who are jointly and severally liable for the liabilities of that entity, they also jointly and severally enjoy the profits of that. So that's what I wanted to know is, do we, that it is correct to refer to that as ownership?
Absolutely.
Great.
Directly
I'm not
ownership.
any questions, but these are the kind of things I want to make sure we've got absolutely correct before we make any assumptions.
Mike, as we've repeatedly discussed, there's many forms of partnership, yeah? And partnership limited by guarantee, for example, the size of the guarantee that each partner holds determines the proportion of their equity stake in the overall partnership.
Ah, that determines an equity stake. Thank you. That's the sort of wording I was after. Thank you. Yes.
Now, you know, that's to my knowledge, that's a very UK sort of thing. Yeah, so you can
That's
have
a very specific kind of partnership, right, as opposed to a general partnership.
Absolutely, it's very specific.
It's really
so you can have
partnership agreement that gives you the ownership.
Yeah, so you can have a principal partner, for example. So you had a partnership limited by guarantee where the total equity stake of all partners was 200,000 something, yeah, and one partner had his guarantee was limited to 100,000, and two other partners were limited to 50,000 each, making the total of 200. Yeah. The partner who has the 100,000 equity stake effectively has control.
Yeah.
Because they have the majority equity holding.
Lovely. So there's an exact parallel to the kinds of relationships that are determined by shareholding that are determined by the percentages in the partnership agreement.
Yes, absolutely.
Fantastic. And we give those the same names of owner, part owner, etc., as we would in the case of ownership that is via the holding of those shares.
Yeah, right. I mean, in the UK, Mike, things like doctors' surgeries are often constituted like that.
Right. In the US, they're often either limited partnerships or limited liability companies.
Right,
yeah.
And there's one kind of limited partnership in which some of the partners have those kinds of percentage of holding, and other partners have their liability limited, and so it's a kind of hybrid, right?
Yeah, a limited liability partnership here in the US.
Yes, in the UK.
So I'll come on to that question now. So then when you create an incorporated partnership that is limited by the issue of guarantees, there is also, presumably in the partnership agreement again, something setting out the percentage of ownership that is enjoyed by those partners.
Yeah, in the UK that's called the partnership agreement.
Right.
It is in the US as well.
Oh, good, because that's what we called it here. So we have any formal organisation has some formal covering agreement, and the partnership, whether it's incorporated or not, has a partnership agreement. And regardless of whether it's an incorporated partnership or not, regardless of whether it's incorporated by guarantees or not, the partnership agreement sets out the percentage held by the partners. I think you know what my next question is going to be. Let me just write this down. Right, whether it's incorporated or not. But what about, we talked last time about how the mechanism by which something can be issued by which something can be incorporated, things can be incorporated either by the issue of guarantee or the issue of shares, i.e. equity. I didn't come across any examples of it, but I think we determined that both of those mechanisms are available, at least in principle, for the incorporation of partnerships. So you can have a partnership which is incorporated by the issuance of shares or some comparable equity instrument. In that instance, does the partnership agreement then not set out the equity holding of the partners, or are there two lots of equity in play?
There's two lots of equity. There's because you've got the limited partners and the general or unlimited partners typically.
Right.
Which I think is prevalent in things like law firms.
Let me just get those words down. The general partners, and what were the other ones called? The limited partners or something?
Limited partners, yeah. So their liability is limited to their equity holding, whereas the general partner's liability is unlimited.
And
control is often is often defined that way as well.
Yes, indeed.
Unlimited. And that unlimited, to go with that unlimited, well, presumably still joint and several unlimited liability goes they still have the percentages of that equity that is set out in the partnership agreement, right?
Yes, the general part,
right.
regardless of how many general partners there are, they are all jointly and severally liable for the entire debts of the whole partnership.
Right. Good.
Whereas limited partners, by definition, are limited in their exposure.
Right, and they're limited by the equity they can hold in the case of a partnership that is limited by the issuance of equity. Is that equity still referred to as shares, or do the instruments have some slightly different name, or what?
There's various sorts.
Right, I'm just trying to tease out the common patterns, but I think that's excellent. So, okay, I can always research some of those kind of details. That was really the meat of what I wanted to get to, and particularly I wasn't sure how those kinds of partnerships work. So there's a nice clear pattern. In all three cases, you have a partnership that isn't incorporated, you have a partnership incorporated by guarantees, and you have a partnership incorporated by equity. In all three cases, the partnership agreement sets out the equity stake of the partners, but in the third case, where there is other equity, you have equity that is in some share or comparable instrument, but you still have the equity set out between the general partners, exactly as in the other two cases. And presumably then in that third case, the possibility of owning a controlling stake can be with either kind of equity, or we really have things that don't happen now?
Well, the controlling stake lies with the general partners in that example. Yeah, I mean, these equities can't be freely traded. Yeah.
Right.
They're written into the agreement, and it's the constitution of the partnership itself.
Now which equity can't be traded? Both lots? Clearly, you can't trade the partnership in a partnership agreement because, as you say, that's locked down in the partnership agreement. So between the general partners, you can't trade
the
that.
holding of the general partners, because they have joint and several liability, they can't. You can't trade that as an instrument or a commodity.
Yes, absolutely. It's not a
even limited partnerships often can't do that as well.
Well, that was my next question. The additional equity that is not held by the general partners in a limited partnership, can that be traded? Presumably, it's like a closed limited company where they're certainly not publicly traded, but could you sell one to your nephew or something?
Yeah, there's all sorts of restrictions around that because it requires the agreement. In order to bring in a new limited partner, it requires the agreement of all of the partners, typically, or a majority of the partners.
So but an increase in
so it's not tradable. It may have it may be used some form of well, actually, it can't even be used as collateral by itself.
No.
That's the thing. Now, that's a good clue as to whether it's fungible or tradable or not, is whether or not it can be used.
No, not really.
It's not a liquid asset.
Within the partnership itself it is, but outside of that partnership it's not.
That's correct, yeah.
And we're still talking about the additional equity in this third minority case of a partnership with additional equity in this case.
Mm-hmm.
Great. So therefore, let me just check this, both the holding of as well as the amount of issuance of the additional equity in the kind of partnership that has equity and is incorporated by that equity, all of that can itself not be changed other than by agreement by the general partners themselves, who are the ones that hold the same kind of equity as in the other kinds of partnership, that is, equity that doesn't have an instrument in it.
Yes.
Right. Right, okay. So now, having got to the bottom of that, when we talk about the percentages that people hold, then we talk about, if you have a controlling stake, would we call it a parent? No, because they're individuals. You call it controlling stake, controlling stakeholder, presumably. I guess the broader question is then how many of the same kinds of relationships we've talked about between limited companies, parent, part owner, significant part owner, subsidiary, and so on, how many of those is there an equivalent to, if any, or is the only term that's really of interest here that of the party which holds a controlling stake? And if so, what do we call that? And just to simplify things, I presume there's no non-controlling ownership. Or is there? Or do the additional stakeholders not have any vote?
Yes. Your limited partners are exactly like your holders of non-voting equity.
Oh, really?
Yes.
Thank you. Would never have guessed that. Right. So, analogy is exactly like.
Whereas your general partners are analogous to your voting shareholders.
Right. That would explain why the general partners are the only ones that can approve changes. That doesn't change as the amount of equity held by the others. Right. Analogous to voting shareholders. Fantastic. I wouldn't have guessed that. That's non-voting equity. So whenever you have a partnership that is incorporated by the issuance of equity, that additional equity is always non-voting. The voting equity remains exactly as it is with the non-incorporated partnership and the partnership incorporated by the issuance of guarantees. Good.
Yeah.
And then what relationships do we talk about, if any? Or do we, if we want to talk about, if we want to extend beyond, say, limited companies to every kind of formal organisation, of which partnerships are one, then do we want to combine the same kinds of, when we talk about, I don't know what you want to call it, majority stakeholder or majority controller or whatever? Clearly, it's easier to track because it's set once and for all in the partnership agreement. Do we still track it? And if we're looking at, say, a data feed that talks about relationships between entities in general, presumably we don't differentiate between the kinds of control. We just say, yeah, this is the majority owner of this entity. So my question is then, which relationships are we interested in at this level? Does the question make sense? I know I'm thinking in a very set theoretic sort of way here. So we're talking about, anything which is a formal organisation at this point. Do we simply talk about control ownership at that level, and the limited company example is simply a specialisation of that? And what would you call it? Majority stakeholder, majority controller? Does that make sense?
Unmuted.
Mike, sorry, I had to be on another call. I realised that we've missed a question as well, which I don't know whether it's been addressed. Chris Barry, I've unmuted your line. Has your question about partnerships been answered, or would you like to pose that question?
It hasn't. Please go ahead. For some reason, my question queue didn't show up properly. I've just seen your question now. Partnerships is also done through joint ventures between two separate corporations. Are you unmuted? Can you expand on that?
He is unmuted, but I believe on voice over IP, so might not have a microphone. Chris, I'm going to put you back on mute purely because there is background noise. Mike, can you answer that question?
I can't, can I answer it as well?
Oh no.
I'm here to ask the questions, and Chris has asked a very good one. Can anybody answer it? Right, I'll repeat the question again. Partnerships, then I'll come back to the question I've got in the box here. So partnerships are also done through joint ventures between two separate corporations. So that has, the first and simplest implication here, of course, is that which can be a partner need not be a human being, but presumably need to be some legal person. We'll come back to that. And so if you have two corporations, they can actually form a partnership, not to be confused with joint venture more broadly as being any kind of venture between them. That's an interesting one. We talked before about partnerships being analogous to, or joint ventures being analogous to partnerships, but very definitely not partnerships. However, from what you're saying, you can have, perhaps it's a minority case, a joint venture which is constituted as a partnership such that the partners are corporations, and therefore presumably this control ownership that lies in the partnership agreement is between entities which are not individual human beings. That's the implication of what you're saying there. Is that a correct summary? Do others agree with it? Is that very jurisdiction dependent? And again, what sort of relationships do we need to track in this case? Is it just joint venture participation with a specific mechanism that it's mechanized by?
Certainly in the UK, there are different sorts of joint venture. There's a joint venture which is a separate corporation with two or more shareholders who hold an equal equity stake. There's also the sort of joint venture you just mentioned, which is basically a limited partnership where each contributing corporation has a limited liability within the context of the joint venture, because obviously they themselves are limited liability organizations. Yeah. So a limited liability corporation can't have unlimited liability in a partnership. That wouldn't make any sense.
Ah, right. So it has to be a limited partnership, and the joint venture participants, being companies, must be limited in their liability.
Yes, because they themselves are limited in liability.
Yes.
You couldn't have $100 million corporation, $200 million corporations having unlimited liability in $1 billion joint venture.
Yeah, so you can't have a limited
that wouldn't make any.
Let's frame this more generally. You can't have any kind of limited liability entity participate in a partnership in such a way.
A limited liability corporation can't participate in an unlimited partnership.
Yeah.
Well, it can participate, but not as one of the limited partners.
Not as one of the general partners.
Correct.
It can be a limited. They normally are limited partners, yeah.
So if there's a venture, then the joint venture participants, if their companies, cannot be general partners. So by definition, if there is a partnership that's a joint venture, it can't only be a joint venture because there must be some partners, right?
Yeah, most joint ventures that we're talking about here, like all of them that I know of, are limited liability partnerships. Yeah.
Mm.
So typically two companies get together and invest a fixed stake. Yeah.
Yeah.
That's what you usually see, particularly real estate development companies here in the States are often set up that way.
Yeah. And here too.
So that means that you can have a partnership in which we talked before about how the general partners have unlimited joint and several liability, and that always exists. But now we're talking about a scenario in which those don't exist. You only have participants who have limited liability.
Yeah. Right? So a joint venture can't have general partners because that would imply joint and several unlimited liability, and that doesn't make any sense if the partners are limited liability corporations.
So
Right.
that means you can have a partnership which doesn't have general partners, right?
Absolutely. Most
Right.
partnerships are limited partnerships. Yeah.
Right.
The ones that are unlimited or limited, they have general partners, are typically not ones you come across in corporate world.
Yeah.
They're like lawyers and doctors and
They're
things
law
like
firms and
Yeah.
accounting firms.
Yeah.
Right.
that. Yeah.
And they used to be investment firms, but no longer.
Yeah. No.
Right. So most joint venture partnerships are limited liability, and there is no general partner that has a limited liability. So that's just, I'm just checking what I'm writing is still correct, because I'm trying to.
Yeah, that's right. They are technically limited liability partnerships.
Right.
That means every partner has a defined limited liability.
Ah. So what we wrote down a little earlier about how all three kinds of partnership still has some partnership agreement for general partners, that's not actually the case in the kind of partnership that has.
We're in murky waters here because in the UK there are limited partnerships and limited liability partnerships, and they're subtly different.
Yes.
Yes. Same in the U.S.
Right.
Okay.
And do those, I presume, so I described at the beginning the three scenarios that I was aware of, and I sort of hope those titles correspond to them, and that is a partnership which is not an incorporated entity, i.e. not a legal person. Secondly, a partnership incorporated by the issuance of guarantees, and thirdly, a partnership incorporated by the issuance of equity. Now, the limited liability partnership, I presume that's limited by the issuance of guarantees rather than equity, or
Mike.
maybe either.
Mike, those things are somewhat orthogonal, yeah?
Ah.
So you've got let me try and clarify it. I'm not sure I'm going to get it 100% correct, but it's going to be close.
Yeah.
You have general partnerships where every partner has unlimited liability. Yeah? You have, I think this is right, you have limited partnerships where you have a mixture of general partners and limited partners, and the general partners have unlimited liability, and the limited partners have obviously limited liability.
Yeah.
And then you have, finally, limited liability partnerships where there are no general partners and every partner has a limited liability.
Right.
Right.
Does that make sense?
It certainly does. So there's two orthogonal things in play, which I admit every partner has limited liability. And in those two cases, a limited partnership and a limited liability partnership, both of which are incorporated legal persons, the mechanism by which they're incorporated, in either case, could be either the issuance of equity or the issuance of guarantees. Would that be correct?
The issuance of guarantees.
I'm not sure about the statement about them being legal persons.
Yeah.
Ah, right.
There's something weird in UK law that I'm not totally au fait with about a limited liability partnership not being a legal entity in its own right. I need to check that.
Because, in the earlier research, we turned up a couple of kinds of partnership which were legal persons, one in the UK and one in the US, with subtly different names. But we didn't tease out all of these, basic core principles that we're teasing out here, which we can then map those things that actually exist onto those core. Not all of these combinations of like sort of Venn diagram overlaps will necessarily actually exist, but at least be meaningful.
Mike.
That's interesting. So, limited liability partnerships. Yes.
Limited liability partnerships are corporate bodies.
Right.
Yeah. They look like limited companies to all intents and purposes, and legally, I believe they're treated the same way.
Yeah. So I can find out which of those that is. There's a detailed description which we've already captured somewhere of the structure of those, and I can now relate that to these basic concepts that we've teased out here, which weren't visible before, is a legal person. Limited liability partnership. Limited partnership, where it's a mix of general partners and unlimited partners. We need to get back to whether that's a legal person or not.
Yeah, it varies by jurisdiction.
Right.
Yeah. Certainly, the UK and the US treat limited liability partnerships differently in this respect.
Yes, I think there's actually similar terms with the opposite names. I think. Let me just see if I can find that.
Yeah, we have the concept of a limited liability company.
Yeah.
Versus a limited liability partnership.
That's right. I'll see if I can find these characters. They're somewhere here. Just bear with me while I go travelling. And then, Carol, you had somebody else who's got a question to...
yes, Chris Barry has added a couple of other comments for you to look at.
Excellent. Somewhere here. I just want to pull up the notes we have so far about those two kinds of partnership, if I can find them. Here we are. So in the UK, there's a thing called a limited liability partnership. In the US, there's a similar thing called a limited liability company. And you can see that I'd only got as far as defining these as kinds of legally incorporated partnership as distinct from, oh, it's here already, limited partnership.
No, the US.
So the US has both. So we get they are different though. The US has limited liability companies and limited liability partnerships.
Uh-huh.
The distinction, as I recall, somebody has to double check this, is that limited liability partnerships are restricted to people, individual ownership, where LLCs can have corporate ownership.
Yeah, that's right. And I think LLPs are restricted to certain types of trade, like lawyers, accountants, architects, things like that.
Yeah, that's all I recall. Engineering firms, accounting firms, used to be investment firms and lawyers, and I can't think of anything else.
Right. So now there's a limitation to what sort of thing may be at the identity end of being the owner. What kind of thing can own a thing, which comes back to our thing whereby terms like partner and terms like parent and subsidiary and so on can only apply when the thing doing the owning is a corporation. So that's nice. So good. You have in the US limited liability company and limited liability partnership. The one we got as limited partnership, we got as being not a legal person, i.e. not having legal personality in its own right. This is from the Investor Words definition. I guess what I could do is look at these descriptions and link them back to the more fundamental principles that we just teased out, and those two orthogonal concepts we talked about, and thereby the kinds of equity that different things can hold, and also now we have the different kinds of things that can hold that equity. Good. So then, and let me just check. So Chris Barry has an update for us. Okay, Chris, I'm just going to run through your comments since you don't have voice. So just around joint venture structures, that comment was there before. Correct. The structures are correct being discussed, such as financing arms with manufacturers. I thought for a minute you were talking about financing arms manufacturers, right? So the manufacturer would have a financing arm, which is a kind of entity which could be a joint venture with the kind of structures you've just been talking about. Excellent. And the structure of the JV will always fall under one of these three mechanisms. Lovely. Okay. So the ones, as you see, when we originally did this, we just pulled these off Investor Words. We didn't try and so here we have a company which is a legal entity. Bear in mind, outside of the LEI world and the legal world, legal entity and legal person are actually synonymous, as they were in the original draft of the model in which we put this.
Yep.
So limited liability company is a legal entity. Limited partnership is not. Limited liability partnership, that's a UK term. So the US thing called limited liability partnership, is that just a synonym for limited partnership, or is it a third thing? Or are we splitting hairs now?
It's actually a company type in the U.S. It is an LLP, separate from an LLC.
Right.
Yeah.
Okay.
It is a legal construct.
Right.
Yeah, definitely.
So there's a legal person. Limited liability company also is a legal person because we have that already. And the UK also has a thing called limited liability partnership, which is a legal person, but in fact that also exists in the States, which we didn't pick up. It's distinct from the limited partnership, which is one that doesn't have legal personhood.
Yeah,
So
so in the
partners are liable to the extent of their investment, so that's the equity holding that's in the partner agreements.
Yeah, so in the UK, a limited liability partnership is treated as a corporate body and has a legal existence independent of any of its members.
Yeah.
Yeah, unlike a normal partnership, which does not exist outside of its membership.
Exactly. And that's what's meant by this being blue rather than orange and having a parent which is body corporate, i.e. Body corporate is a kind of legal person.
Yeah.
So fantastic. So that validates that, because sometimes looking at the investor words definitions doesn't quite tell you enough to know if that's correct. So that's great validation of that. Thank you. And likewise, there's actually two US type things, one of which we have here, one of which we don't. Can add that. So let's just add it. This person.
Oh yeah, Mike, just to finish that off.
Yep.
Limited, both partnerships and limited partnerships are not separate legal entities, but a limited liability partnership is a separate legal entity under UK law.
Right.
Got that?
Let me just write that down before it evaporates. Both partnerships and limited
partnership are not separate legal entities, but a limited liability partnership is a separate legal entity. It's because of this. It's all because of this joint and several concept. Yeah.
Ah.
The whole concept also, certainly in the U.S., the tax code has some significant bearing on this. In the U.S., in a general partnership, as we're calling here, the taxes are they have a concept of pass-through taxes, meaning that they get reported by the partners individually.
So would you say these reflect these legal realities, or do they drive them?
They're separate. They're kind of orthogonal, Mike.
Oh.
Because it's true in the UK too that the tax regime or tax treatment is different amongst these different types of partnerships.
Yes.
Mm.
So I think a lot of this came about. So the general partnership and the jointly and severally liable concept in a general partnership sounds like it's consistent.
Yes, the liability
in the US,
include the tax liability.
The taxes are for that kind of organization versus LLP, LLC, INC, etc. They're all considered as a separate entity and report their taxes individually as individual entities, I should say, versus relying on the partners to report their tax implications.
Yeah.
Right. So it does pretty much reflect, if you've got legal personhood and you're capable of carrying liability, you carry the liability for tax. If you don't have legal personhood and the liability is held jointly and severally by some participants, i.e. partners, general partners, then those are the ones liable for tax because they're the ones enjoying the profits.
Well, as a generalization, I think that's reasonable, but you need to be very careful here because this varies in its detail wildly amongst jurisdictions. Yeah.
Yes.
Almost every country treats it slightly differently, and even in the US, as I understand things, I'm no US expert, but I understand there are different treatments even by state.
There can be, yeah. For the general things, they're largely the same, but they can be different. LLP, LLC are generally treated the same across all states, but I'm sure there's some nuances in probably state taxes. And that's because the federal taxes in the U.S. largely define the structures that are acceptable to the IRS.
Yeah.
Whereas a state could well come up with some other mechanism for legal personhood, but the federal tax regime needs to, yeah, I'm sure similar things.
Right, exactly. That's where you'll find the differences in how they.
Good. So luckily, I'm not even going to attempt to model tax, but that's really helpful in getting us down to the bottom of where the liabilities go, what the different participants can be and do, and so on. Good. So then we can talk about then of all these relationships. Let me just go back to the diagram we were on. Okay, diagram's really just a collection of notes at the moment, not really much new modelling in it, but we can talk about, okay, so we know what kinds of relationships can exist that are more general than just limited companies. Then when we talk about majority owners, part owners, part owner here is defined at the moment as being significant voting stake, but not 50% or more, because 50% or more would be a parent. And of course, in the LEI, there's a new term also called parent, which is 25% or more. So maybe I've used parent as a synonym for control owner, and maybe that was incorrect. But now we can see that this kind of ownership need not be limited to limited companies. Yes.
Mike, when you talk about owner, the concept of owner, I think you need to go back to that discussion we had the other week about the difference between de jure, de facto, etc.
Right. Now that was on control, wasn't it?
Yeah.
Yeah. So in fact, so we've modeled de jure control, de facto control. When we talk about owners, are we always talking about control then, and we're never actually talking just about?
Well, that's what I mean. We need to be clear in our semantics, I guess, on what exactly we mean.
Exactly.
In terms of owner versus control. Owner, to my mind at least, is strictly to do with the apportionment of equity.
Exactly.
Mike,
and
while you're
talk about parent and things like that, it seems to be correct that we're only talking about the
control.
Control
parents.
Equity. Yes.
Parents is to do with control, but it's a Venn diagram, yeah?
Yeah.
Because who owns the voting shares creates the intersection set.
Exactly. Right. So parent is control. Right. So that's what I was hoping, and that's what we have at the moment, is that this concept of parent sits under voting shareholder. Now, we've seen how there are other kinds of control now in partnerships and things. This only refers to companies which are themselves shareholders and companies.
Parent company speaking only refers to de jure control, yeah?
That's right, yep.
So to be a parent company, you have to own more than 50% of the voting equity to be a legal parent, yeah?
Yes.
But in the world of financial services, we're not just interested in legal parents, we're also interested in what I might very loosely call risk parents, who may not own 51% of the voting stock of a company, but have effective day-to-day control over it, and therefore make decisions which influence the financial stability and everything else to do with that company.
That's right. Yep. So somewhere... Somewhere we've modelled those three kinds of, we've actually voted them to being social constructs of some sort. I'm going to find them now, of course.
Mike, there's a question as well, or a comment. Comment from Cornelius Crowley. Cornelius, your line is released. You can actually join the conversation.
Okay, thank you. I was just, it wasn't a question, it was to highlight. Mike, I heard you mention the LEI and the 25% figure, if I heard right. My comment was just that the private sector participatory group and the implementation group continue to discuss the concept of control and ownership and how they will identify parent and ultimate parent in that construct. So they have not landed on a final definition there. So as you can see from this discussion, it is a complicated topic, but I just want to clarify that they have not issued a final definition on what that is.
Thank you very much. So, whereas it's suggested in some of the working materials that we've seen that there's a thing called parent that's 25% that's not been finalised upon, if it was, we'd have to think of a new label for it to distinguish it from the current understanding of parents being 50% or more, which we've just heard again and validated. But even if it's called that, I guess what you're saying is that actually this whole question of the different semantics of ownership versus control ownership and so on are very much part of the ongoing conversations about what relationships are of interest in the whole LEI conversation. Is that correct?
That's correct. It continues to be an active area of discussion, but definitive word has not come out and probably won't for some time until after the global LEI facility is up and running and the legal entity is established and all that. So it continues to be an item for discussion.
Right. So would it be fair to say that in our semantic modeling, instead of trying to add relationships that anticipate what comes out of the LEI, the most useful thing we can do is to find the kinds of relationships that are already understood and refine these kind of nuances we've been talking about today, so that when you talk about things, there are concepts to point at and say this is what we mean at this point, and that's not what we mean, and this thing over here is what we mean at that point. Is that a helpful thing to have?
Yeah, because they are discussing such things as in identifying an accounting convention, which may be 50%. You have the 25% here. I know that that may be a little confused with what the CFTC has put out in their rulemaking, which is Part 45, and there's a definition on there for the interim compliant identifier. They had spoken of a 25% figure. Some of the information that I'm collecting is across the regulatory and supervisory community within the U.S. and their various rulemakings, which do center around the 25% figure, but then there's a lot of caveats that go beyond that. We're down to 10% and 5% levels under various conditions. So it's not a clear-cut rule among the many regulators, and I have about 5 or 6 I've pulled together, and while 25% in that community seems to be a number you see a lot, again, I'll say there's a lot of caveats around it. And for the, again, as the LEI discussion is evolving, there's a lot of discussion about the accounting rules or the rulemaking in the jurisdiction under which a legal entity may reside. And say, well, for that jurisdiction, if it's a 25% figure, then perhaps that's what would be used as the determining factor for parenthood. Or if it's a 50% figure under the accounting rules for that jurisdiction, then that would be the figure that's used. So as I said, there's no definitive answer on this, but it continues to be discussed.
But as you rightly said,
wouldn't it be divided up into ownership versus the threshold for control versus the threshold for regulatory interest? And I agree with you; all of those are in debate, but those concepts are being developed now.
Yes, it's what you said. What you said just then, Mike, because whatever the outcome of the LEI-based discussions, that's only going to create a new flavor of definition of de facto control. It can't override the de jure control definition of each jurisdiction.
Right.
And we should not try. And I'm thinking that we're talking about how do you implement an analysis or an operational ontology that would say, give me something of interest versus the legal definition of control. And in the business conceptual, please keep it legal.
Thank you. Fantastic. So basically, we define all the terms that have a legal grounding, and we don't try and match or anticipate stuff that's of interest in looking at
we'll have to implement it, Mike, but we don't want it in business conceptual ontology.
Fantastic.
Yeah.
Yeah, this is Bill Freeman. I would agree with Cornelius in that, positions data can change overnight. Asia values positions and valuations different than the U.S. It may be the same actual security. It may be valued differently, and that might indicate a difference in the level of ownership based on valuation. So closing the books every night, uh, getting positions based on different valuations implies, cross-currency conversion and many other things. So it is an implementation issue, I believe, that can be looked at in terms of establishing if-then rules, business logic, I think also inference and reasoning to try to make these determinations. They're complex. I think FIBO's got to have those legal definitions is fantastic. The actual operational issues are going to be broad and probably event-driven and driven by covenants, even in documents between companies. So,
agreed, Bill, but we're keeping it out of the business conceptual. That's a separate activity.
Yep. Fantastic.
Yeah, that's what I was saying. Yeah, thank you, Mike. That's what I was trying
thanks,
to say.
Bill.
You said it much better.
So operational issues are separate to what's modeled in this legally grounded model. I say legally grounded, that might include what's defined in accounting jurisdictions. I think, so de jure is what's legally grounded. I think we can talk about the existence of de facto control without attempting to refine it in any way. We can just say, well, there's a de facto controlling entity and leave it at that, or just leave these out completely and just talk about de jure control.
I like the concept of deemed control because it does allow you to implement a percentage based on a varying regulatory requirement. So kind of conceptually it makes sense to me, but
Great. So we just define it as one kind of concept, and then the percentages are a matter for the reader, as it were, a matter for the implementer. Yes, fantastic. Good. And then we can not worry about a lot of things that we've been encouraged to worry about by reading some of these materials. This is great. This is exactly what I wanted. And then the deemed control and de facto control, presumably, I haven't connected these up to anything yet, but presumably these would apply at the highest level of basically any kind of formal organization and or any kind of body corporate, any kind of legal person. Obviously, you don't have de facto control of humans, but you talk about these other kinds of control at the most general level, and then they can be split down to different levels of equity in an application by looking at obviously the kind of entities which do have equity, which we've now I think explored fully, which kinds of entities have equity and which ones don't, and which kinds of equity they have when they do, and that in fact the de jure ownership can be defined accurately for all of those. Deemed control can be defined much more generally, and probably data feeds would be maintained which simply assert some kind of deemed control without saying how it's mechanized, and so we can actually talk about those concepts.
So Mike, are you making it overly complicated with these various kinds of control? Because unless there's a fixed percentage affiliated with, the ultimate parent or something like that, it's really going to be a variable figure.
That's right. So I think just keeping that as the most general concept that just is defined around the most general kind of entity, the de jure kinds of control that are based on equity can be more formally defined around the kinds of equity that actually exist, and as we've seen, the limitations of what kinds of thing can hold that equity, which is itself fairly complex, but it gets us away from having to track a level of ownership just in case it represents a level of control. We can actually talk about when we're formally talking about control, de jure control, and when we're not. Does that make sense? Not really. Okay. Yes, I think what we've done here is get down into the details of the de jure side of things. I think that when we talk about deemed control and we talk about de facto control, we can keep it general and keep it all around the level of, well, control of formal organizations by bodies corporate or by incorporated companies or by legal persons. This is where we might end up overcomplicating things. Let me just have a look at some of the other terms that I've got here, because these may be, oops, that one definitely is over complex. We don't want that one. Not sure we want that one either. Okay. Yes, I got some very complex diagrams from earlier on, and I was trying to find where I'd simplified that to talk about. It's really just these three relationships here, I think. Body corporates having control of, say, some incorporated company or some other body corporate. Formal organizations having legal control or being legally controlled by something else. And I think these relationships are probably in the wrong place.
Mike.
Yes.
Igor, I don't know whether or not you can speak because you're on voice over IP. I've released your line. He's got a fairly long comment that he's added to the questions. Igor, can you speak? No, perhaps not. So if you could perhaps read that, or unless you want me to.
There we go. So we have, if we follow the paradigm of adding a country ID to a term, e.g. limited partnership, US, etc. So commenting on where I'd been naming these kinds of terms with these different names, like I'm trying to find them, the US and UK variants of kinds of partnership, then we may end up with an unmanageable number of terms. Absolutely. I think we could recur to a couple of options. Create a general term like legal entity type, and treat concepts such as limited partnership US, limited partnership UK, limited partnership RU, and so on as instances of this type, or create general concepts like limited company, limited liability with domicile or scope attributes. Thanks, Igor. I think you're right, and I nearly mentioned this when we were here, and then I didn't. So way back in the beginning, we put in these terms with UK and US in brackets, which will probably also kill any semantic web reasoners. I'm sure they don't like these braces and things. Put it there to see if anything broke. But I think when we originally captured this, and I added this one in now just to capture what we got in our conversation, but let's pick up Igor's point now, because I'm not going to try and model it now, but it seems to me that when I was writing this, I was just capturing stuff that was in investor words, and even in reading this, I struggled to parse it because of these different kinds of roles, which we've now gone through in detail. It should be possible then for us to throw away all these named things with braces around country names and so on, and talk about the different kinds of partnership, the different kinds of liability, the different kinds of equity that we've just talked about. And of course, those different kinds of equity then allow those kinds of organizations to participate in the kinds of ownership with control and the kinds of ownership without control relationship as appropriate to the kinds of entities that equity that we've teased out. It's going to be a challenge to model, but I think with what we've learned today and written down in all these boxes, and do please reread this when it comes out in the notes to make sure I haven't written any of it wrong, that if we can model those generalities, this comes back to our original aim of being able to define what are essentially buckets of kinds of entity that can exist in any jurisdiction regardless of what they're called. And then some of the specifics, there's two things we can do with the specifics, back to Igor's point. One is, of course, from an implementation point of view, you just read the relationship between the entity and its domicile. So just as every human being has a citizenship, so every non-natural legal person has a domicile relationship to a country, and then you can read from there back to the jurisdictions that apply in that country, and work it out from there. Or, of course, as we've done with limited companies, doesn't show up on this diagram, but you'll see in many data models a selection list of legal form. We've got rid of that because all the legal forms are themselves these boxes, these kinds of things defined by their characteristics. But what's left behind is the local country or jurisdiction variations in the kind of styling of, if you're an incorporated company, it could be LTD in the UK or PVT in South Africa and so on. And so that we could even do that kind of thing as a kind of naming convention selection list if we wanted to, but that would be quite long because we'd have to research all the possible names of these kinds of entity in every jurisdiction. What we should, I think, do is take what we've learned now, take the specific examples that we got here from the UK and US, and reframe this whole landscape around partnerships, the two, as we now know, orthogonal things that are with or without liability, which is reflected here, and with equity versus with guarantees. I think in the partnership model, we may have the beginnings of this for one of these, and we can now extend it to the others. I think I modeled it for one without really knowing how to get to the bottom of the rest of them. So let me have a go at this now. Where is it? Legal person, no, organization, partnerships. So what I did for one, we can probably do for all, which is define the partner's legally incorporated partnership member for the US one. So this needs to go back to these more generalized things we talk about, registered agents. Some of these are going to be very jurisdiction specific, but I think similar to what I've done here, we can now define general partner versus whatever the other one was called, everything we talked about earlier on. Limited partner, thank you. I'll just jot that down in fact so I don't miss it. These can be modeled as kind of parties, and then they can be directly linked to the kinds of relationships we talked about. And so we talk about, what's the kind of Venn diagram kind of intersection of all the kinds of control relationship, all the kinds of ownership relationship, and so on. So thanks, Eagle. That's very, very timely. And that's where I'm going to go with this. Yeah.
Mike, it's Phil here.
Hi, Phil.
You in that same set of thinking that you're going to be doing.
Yeah.
I believe you also need to consider the synonymic concepts of affiliate or associate company.
Ah.
That's where, well, there are two distinct situations. One where company A holds a less than majority shareholding in company B.
Yeah.
Yeah.
By less than majority, you mean less than 50%?
Correct, of the voting stock, yeah. So they have a substantial but non-controlling, non-legally, non-de jure controlling interest, yeah.
Yep.
And the other situation that's often referred to in that same conversation is a situation where you have two companies or two organizations that are associated through common partners or common directorships.
Oh, yes. Depending on the kind of entity, we could be talking about directors or we could be talking about partnerships, but partners, but the same kind of concept applies, which is that the same people are participating in relationships.
Yeah. So you've got companies that are related through some kind of equity ownership and companies that are related through having common principles. Principles as in ALS at the end, yeah?
Yes, we have companies which have common principles, write this very carefully, principles.
Yeah.
Now, should we define principle as a kind of general parent term of which director and general partner are both specializations of principle?
Well, yeah, they're the executive, aren't they?
Yes. Ah, and the executives we already have as a concept in the detailed control diagram. Yes. I've written that thing twice now. Director, I meant to say director.
I think principals is the legal term, but executive is the more common commercial term.
Right. So we're saying executive is synonymous with principal. Let me just show you what I've got for, because when we talked about kinds of control, and one of the kinds of control we talked about in our earlier conversations, so these things always go long and thin before I can tidy them away, right, is we talked about under kinds of control, as well as this de jure and de facto control between entities, we also have managerial control, board membership, and so on. Now, this is where there's some very big and hairy diagrams. This one is the one I simplified. You wouldn't believe it to look at it, but you see that it's half blank over here. Okay, this is one where we just have legally controlling party. This was the one I was looking at. It's just more complex than I thought. That's something that has vested in it some legal control. The executive is a kind of legally controlling party. And then in the original model with all of that in it, we expanded it out. No, it's not that one.
I must have missed that meeting because I don't agree at all that an executive is the legal controlling entity. The executive is the executive controlling entity, not the legally controlling entity.
Right. Now,
they're appointed by the shareholders to do
their... This is in the earlier researches, so this is wrong.
Well, an executive is completely appointed by the owners of the company to do their bid, by the equity owners to do their bidding.
They act on behalf of the controllers.
Yeah, exactly. So only in a partnership are those two things the same legal person, if you like. In almost every other type of company or organization, they're two very distinct things, aren't they? The people that run the company, the executive, and the people that own the company.
Right, thank you. So this is something from some of our earlier reviews. We talked about legally controlling party and executive being part of that, and that's not the case at all.
They execute things on behalf of other people.
That's right, and therefore we had, if I can find the diagram with it in, this is where it gets very big. We had two things like corporate public officers, which is some kind of responsible party, and an owning party, and we have the votes and approves relationship from somewhere deep in the guts of this thing here, any voting shareholder, be they a corporation or not, votes and approved board members, you have executive and non-executive board members. Executive, therefore, has a kind of control that we haven't separately defined. That's what's missing, which is managerial control. Now that we've actually defined control as a kind of thing, which we did as a result of the previous session in this series, we can talk about managerial control as a kind of control.
Yeah.
Mike, I think these are exactly the right concepts. We did an interesting analysis where we went into the DTCC and selected all directors that had any association with, in this case, we used Staples. The map that came out of that was really interesting because the nesting of varied interests who actually owned and may not have had official control, but they may have been a director that owned a boatload of shares in Staples, but put them in a trust for their, in their wife's name, So it can get, pretty interesting. And not only that, but then we related those owners to, or those directors that had any kind of stock shares. We related those people to people that own stock in other office supply companies like Staples, like Office Max. And
This sounds familiar. When I worked for Dun & Bradstreet, we worked on something called the Web of Influence, which is to do with affiliated companies who are affiliated through either direct ownership of equity, having common principals, directors, executives, whatever, or where people have got common stock holdings in multiple companies.
Yeah, so it's more of an application level, you know. I'm not suggesting that that's something to be in FIBO, but that's the real world. And we used an ontology called Friend of a Friend. And we used information out of the DTC and created some very interesting maps where we could really get some tremendous visibility into actually whether or not it was legal, but who really had the control, you know?
Right. Well,
who really? Yeah, who really runs the world?
Oh yes, is that thing where you end up with a map where there are about 5 banks in the middle of this whole web of stuff?
Yeah.
Yes, yes. When you talk about common stock holdings in multiple companies, you talk about across the single industry sector or something, so you start to see.
No, just generally. Oh. So if I'm a CEO of company A and I hold the stock in company B and also a large amount of stock in company C, A, B, and C are all interrelated in a subtle way through me.
Ah. So a controlling owner in one entity, not a management owner, a CEO in one entity, which is a managerial control executive, may hold
and then I've got equity in others.
Stake. I'm talking about voting equity, presumably in another company.
Yep.
This effectively relates them.
Yep.
Wow. So we've got relationships across the kinds of relationship that we've teased out the differences between.
Yep.
Right.
And when you start to look at the reasons why companies collapse, this becomes very, very important.
Right. Well, I have no idea how to model that.
I know.
It's maybe an exercise for the implementer. And for those who don't know, friend of a friend, in the semantic web, there's a few very well used and well known formal ontologies or semantic models. And there's one called friend of a friend. It's a very simple and very widely used model which tracks basically kinds of person and kinds of relationships between person without the kind of legal grounding and formality that we've been attempting here, but just very simply enabling you to talk about relationships between entities and assert relationships between entities. Bill, is that a reasonably accurate?
Yeah, absolutely. In a former life, we used to talk about a concept of what we used to call stealth ratings, which are based on these non-transparent, non-easily visible interrelationships between entities.
Right.
As you say, it's very hard. Well, it's quite complicated.
You just assert them.
Those are application issues that actually. You can ultimately build out these applications to discover this, but to have the baseline, FIBO ontology as the basis for, vetting, what the definitions are, and I think that's the more important thing, because the other stuff, the covenants, the stuff that are written on the 400th page of a pooling and service agreement, in a note, that affects ownership, those are all applications, I think.
Yes, I think teasing a lot of that out is down to doing some formal reasoning over the instance data and saying, as long as we can talk about the kinds of relationship, and with both you would simply think of a new name for a relationship and assert it. Now what you can do is incorporate the FIBO types of relationship and assert more precise kinds of relationship using, say, FOFA and FIBO or something, and reason over kinds of relationship we've now named. But the interesting stuff will still come out of traversing the tree of actual data that has these different kinds of relationships in it.
Totally agree. Totally agree.
Fantastic. That's,
yeah, I think a good example, with what we do with anti-money laundering, right? You don't know right now what you don't know. You may find a clue, somewhere down the road, but meanwhile, you have to aggregate data about, say, an individual or an action or a behavior or a transaction, and you have to hold it in kind of queue, looking for additional facts to potentially alert you that this might be a bad guy or something. So,
yeah, that's the Rumsfeld model, isn't it? Yeah,
that's right.
exactly.
So if you're using a master data management system, it's fairly simple because the number of classifications are 5,000. When you're looking at aggregating information to hunt for clues to hunt down bad guys, you're talking about those petabytes.
Yeah, and you got techniques like visual analytics where you have different ways of exploring the web. And now that we've got different kinds of relationships, as long as you know where the instance data is itself clearly defined in terms of one kind of relationship and not the other, and you're not getting them all mixed up, then you can say, right, let's make the de jure control blue and the de facto control green, and let's explore this web. And oh, look, there's a little cluster over there. What are those things? And you can find patterns that you couldn't programmatically anticipate you'd be able to find, but you can, the more semantics, the more nuances of the kinds of relationships there are, the richer the kind of model you can then explore, either visually or via algorithms that go looking for autocorrelation functions or whatever. And as you say, you start to turn out, the Rumsfeld thing, the things we didn't know that we don't know.
Exactly.
Whereas in the conceptual model here, we can only start to talk about the things we know we don't know.
Yeah, it's powerful stuff.
It is.
Yeah, but that's okay. It's where you have to. It's what you really need in order to do the other stuff. Ultimately.
Exactly. So with the kinds of, and this is why even down to having kinds of control, and I've got to add management control here. All sort of things as well. I won't try and do it now, but I have management control here. That you could explore those using different colors or different layers, turn them on and off, look at relationships. And also, most importantly, when somebody sends you a feed with a search of the relationships between things, be quite clear whether that feed is talking about de jure, de facto, or whether it's being vague and it just applies at the parent level and you don't know what sort of control it is, so that you know what assertions the data feed is making when it shows that something has a 25% something of something else. You know what you're talking about. Cool. Well, that was a nice kind of roundup of the potential of this. We got through a lot more detail earlier that I think answers a lot, if not all, of my open questions about where to pin the ends of some of the more general kinds of relationship. We can talk about control. We now know all of the mechanisms that exist for equity-based control. I need to flesh out the kinds of partnership in order to connect up those kinds of relationships. I also need to put the parties in those partnerships, like the example I showed you, but based around the nuances we talked about. Those can then be kind of Venn diagrammed with other limited company-based types of relationships. So we can talk about whether it's a relationship that, in this data feed, you don't care whether it's based on a limited company or a kind of partnership, but you know that it's a 50% plus one controlling relationship, for example. So a lot of modeling to do, but I think we've got down to the bottom of all the answers and things here.
Mike, excuse me, sorry, it's Phil here.
Yeah.
We talked a lot early on about the subtle differences within jurisdictions between limited partnerships and limited liability partnerships.
Yes.
There's one more you need, unfortunately, you need to add, at least one more you need to add to the list.
Right, go, yeah.
And that's the limited liability, limited partnership. Which I believe is a US-only construct. But I'm not 100%.
That one.
Could it be that this is the intersection of those two orthogonal things we talked about, whether liability is limited or not, and whether there's equity or...
It might. You'll have to look up the definition because I'm not 100% sure on exactly what it is. I know it exists. I know it's a separate legal form.
Right.
Again, these kinds of things are set up by states. I'm not aware of it. I mean, there's an LLP, which is a limited liability partnership.
Yeah, there's definitely something called a limited liability limited partnership, as well as the LLP and the LP, or general partnership, and general partnership, sorry.
Right. So if I model those two non-mutually exclusive facets that we talked about, the liability and the style of equity versus guarantee and so on. There's a number of things that could logically exist, some of which may or may not exist, and this may be one of them that turns out to exist after all. Or it may turn out to be it's not that at all, and the name is just confusing me. And if I do a little search on that, I will find out.
Yeah, apparently the limited liability limited partnership, as I just mentioned, is quite a new thing.
Oh, okay. So the question then becomes, is it a new intersection of existing mechanisms, or is there a new mechanism in play that makes a third facet of the kinds of thing we can say about partnerships that we didn't know about in our earlier conversations? So is this jurisdiction created some new legal instrument or legal power?
It certainly only exists in currently only exists in certain US states.
Right.
Arkansas, Arizona, Colorado, Delaware, Texas, Kentucky, Georgia, Maryland, and Florida, I think.
Okay, that's a fair slice of states. Cool. Yeah, that looks very similar to the list of companies that have something called a benefit corporation, which is a whole other kind of entity which I had to figure out about another time. But that's definitely a different kind of entity. That's almost a subtype of limited company with without an obligation to make profits for its shareholders.
Yeah, I think the weird thing about this particular legal form is that in this one, even the general partner's liability is limited.
Ah.
So normally a general partner is unlimited, yeah. You join me in seven. I think in this one, even the general partners have got some degree of limited liability.
So this is in answer to my earlier rhetorical question, this is a third thing. It's not an intersection of what we've already talked about. It's a new legal arrangement altogether. Now we can have general partners that can either have limited or unlimited liability, whereas up to now they can only have limited liability. Right, interesting.
Yeah, I've not seen one of these things in the wild, so I don't really know exactly what they look like.
Right.
But they definitely exist. Apparently, they exist a lot in real estate, allegedly.
Ah, so we're bound to come across those when we start picking apart the MISMO loan mortgage-backed security type of terms.
Oh, this is interesting. Apparently, CNN is a limited liability, limited partnership.
Oh, right. Look no further than CNN's website then. Great. Okay, well and that kind of reinforces back to Eagle's point that we'll get rid of the little things with brackets in their, the curly braces in their names, and talk about each of these mechanisms as being things that can apply in the realm of partnerships, and whether they all exist or not will be a separate matter, but we'll at least define them and the powers that go with them and the kinds of agency that goes with them, and that gives us something to process in terms of all these kinds of relationships when we start doing stuff in applications. Good, that's a lot to do. So, no meeting next week. I suggest no meeting the week after, since it's the week of New Year, unless I know some people like to get back to their desks early, but my suggestion would be to knock off for both of those weeks. Does anybody think that's a bad idea?
No.
Good. So that gives me time to model some of this. I'm working on an interim draft of just the stuff we've already modeled, just to get some of the technical formalisms in place so we can get a bit of a baseline of that. All these nuances won't be in that interim draft, but what they will be in by the time we meet in 3 weeks' time is I'll do that modelling we've just talked about, flesh all these things out, present this back to the group, and see if we can more or less draw a line under the kinds of relationships that are appropriate to have in the business conceptual ontology and that are needed for the kind of processing we talked about earlier about those friend-of-a-friend type of networks. So with that, thank you for staying on. I know it's 4 minutes over. Any final comments or ghastly errors I've made or things I've missed before we sign off?
Mike, it's Phil here. What kind of where are we in the publicity stakes with this?
Where are we in the publicity stakes?
Well, how is our progress being publicly made known?
Mike Atkin, would you?
Yeah, so there's a couple of components to this, Phil. One, we are meeting this week with OMG to structure the standards release process for business entities and align it with the other things we're doing on FIBO, particularly on operational implementation and some of our proof of concepts. That standards process, once we kind of define exactly what the deliverables are in a time frame, we'll kick it into high gear for full promotion. We are talking to lots of our members now about its use and mapping, and people are looking at it and playing with it, so there's a lot of EDM council member visibility currently underway. There's a lot of visibility within the Financial Stability Board's LEI conversations on hierarchies and relationships, so we've presented it to them. It's a idea that is part of that conversation. And there's onward activity with the regulators. So once we get some of that sorted out, put into the right boxes, we go kind of full go-to-market.
Okay, that's great, Mike. Thanks. I only asked because, I mean, you know what bosses are like, and my bosses ask me, they say, this stuff that you're doing sounds really good and really important, but when do we get any visibility of it?
Well, it's, yeah, so I think, once we get this standards process, we've got a few things that are up in the air. It's kind of a complex set of activities, so we're sorting that out and narrowing it down. Once we agree on that, we're going to do the visibility and full exposure.
Fantastic. Thank you,
all
Mike.
good stuff, Phil. It's just, we need to put things in the right box.
Yep.
Yeah, that's brilliant. Thank you.
Excellent. Thanks, Phil. Thanks, Mike. So with that, I think it just leaves for me to wish you all happy holidays of your choice over the next couple of weeks. And thank you very much for, again, some really helpful and impressive input. And I'll do my best to live up to it in the modelling of it. And we'll meet again after the New Year, but not the week the New Year actually happens, but the week after that. So have great holidays, everyone.
Thank you, Mike.
Enjoy a break.
Happy holiday yourself.